Well, good afternoon and good morning, everyone. I'm Dan Stanton, and I'd like to welcome you to our webinar on foreign interference. Just two quick administrative issues before I get into the introduction. We are providing simultaneous translation, and there's a Q&A box that you're welcome to put any questions as we go along, any questions, any comments, and I hope to get to them, get to all of them at the end of our speakers' presentations. So just by way of introduction, this webinar is being hosted by the National Security Program of the Professional Development Institute at the University of Ottawa. I'm the director of the program, where we offer courses, workshops on the salient issues of national security. We have former practitioners, such as the three of us here today, as well as academics who provide very specific subject matter to participants in the course. In addition to the teaching, we also host various events, such as webinars. Last October, we had a large event on women journalists targeted by transnational repression. And we've had some other webinars related to this subject matter, but not as comprehensively as today. Really excited about the speakers we have here. I know them both very well. They're instructors in our program, in our national security program. Jerry Normand, who worked many, many years for the Government of Canada and the Justice Department. He's quite experienced. He was actually the lawyer when I was an affiant for the first time for a warrant in CSIS, Section 21 warrant, which the judge signed. And Guillaume Como-Tremblay, who also is an intelligence officer like myself in CSIS. He's worked in national defense. He's very, very experienced, with a particular specialization on transnational repression. So without further ado, I want to turn this over to our speakers. They'll probably give you a more fulsome introduction, and we'll proceed with our webinar. Guillaume?
Good day, everyone. Thank you. I'll just share my screen. All right. All right, I'm very pleased to be here today. First of all, I'd like to thank Dan and the Professional Development Institute for organizing the event. And it's a very important topic, as Dan mentioned. There are already a number of people who have shared their views on Bill C-70 and the report from the public inquiry into foreign interference in interviews, podcasts, and online. But I have yet to hear anyone speak specifically about their transnational repression aspects. Since this is my area of expertise, like Dan mentioned, I thought it would be a good idea to share with you my opinion on the law, but mostly on the final report released a couple of weeks ago by Justice Marie-Josée Hogue, and the commissioner leading the public inquiry. Before I begin my presentation, I'd like to make two very shameless plugs. First of all, like Dan mentioned, I teach a course on transnational repression and foreign interference at the PDI, both in French and English. The last session in French was last week, but the next one in English will take place at the end of March. There's still seats left. You can see the course description on the screen. You can also use the QR code to access the PDR's webpage, and you can register from there if it's a topic that might interest you. We also offer group training, so if you think your team or your organization might be interested, you can contact us and we can deliver that. It's a course focused on the methods, the actors, and the victims of transnational repression. We'll look at the Turkish, Iranian, Indian, Chinese case studies, in addition to many other examples discussed throughout the 6-hour-long course. Also, last fall, like Dan mentioned, we did webinars. We did one in French on the Chinese police and transnational repression. You can find the recording on the PDI's French website if you're interested in this topic. You can also use the YouTube link to get automatic English subtitles. If you do not understand French, you should be able to understand most of the content. All right, without further ado, let's discuss the final report from the public inquiry. To begin with, unlike Justice Hogue, I believe we do not have a uniform definition of foreign interference in Canada, particularly as it relates to transnational repression. In her report, she states that the working definition of foreign influence is generally consistent across government departments and agencies. In my opinion, multiple Canadian agencies have their own definition, which differ from one another in what they include. So let's look at them a little bit. CSIS used the definition from Section 2B of its act. This definition covers both foreign influence against democratic institutions and transnational repression. Unlike CSIS, CSC uses a definition strictly limited to foreign influence against democratic institutions. Although I know the definition of foreign intelligence in the CSC Act will include transnational repression, and I know, and it's reported in the public inquiry report, that the agency, that CSC, has been having an active interest in this threat recently. The definition provided by CSC to the Commission makes no mention of transnational repression. Now, the RCMP's definition of foreign influence is very, very broad, encompassing virtually all threats from foreign states, including espionage, cyber attacks against critical infrastructure, and transnational repression. So you can see from CSIS's, CSC's, and RCMP's definition that the leading agencies working on foreign influence in Canada do not seem to agree on what is included in FI or not. And this is not just a semantic issue, right? The criteria for inclusion are important when it comes to establishing common strategies and collaborating. In addition, a growing number of actors in Canada are interested in foreign influence. The different agencies at the provincial, local level, NGOs, researchers, we need a common definition to have a common understanding of this threat. Specifically on the topic of transnational repression and definition, I find the definition chosen by the Commission to be a bit confusing. At one point in her final report, Justice Hogue uses the FBI's definition, though without attributing it to the Bureau specifically, the one on top you can see on the screen. This definition is, in my opinion, the clearest and most complete that has been put forward so far. However, elsewhere in her report, including in the summary, she uses a shortened version, the one at the bottom. And that one eliminates the most serious forms of transnational repression, i.e. the silence, coerce, or harm the victims. She also claims that this is actually the definition CSIS uses. So the report is unable to provide us with a single definition that will reflect the federal government's vision of transnational repression. We also learned from the report that CAC has been working on such a definition since 2023, but we still haven't seen it yet. Now, on the importance of the threat to Canada posed by transnational repression. I couldn't agree more with Justice Hogue's findings. She claims it would be challenging to overstate its seriousness. Specifically, as the former active National Security Intelligence Advisor, David Morrison, quoted in the report, points out this is a greater threat of foreign interference to our country than foreign interference against our democratic institutions. As I emphasized repeatedly in my course on transnational repression, unlike any other threat to national security, this one has substantial and persistent consequences on many Canadians on a daily basis. I specifically want to commend Justice O for interpreting her mandate as broadly as possible to include transnational repression. Although she was criticized for going not far enough in her report, I think she quite clearly explains the limits imposed by the Commission's terms of reference. She'll still manage to hear from many witnesses on this topic, including representatives of target communities, despite the short time frame available for the public inquiry. So while it could be considered incomplete, the result is a very good overview of the current threat of transnational repression in Canada. She even goes so far as to name Iran, India, the People's Republic of China, Russia, Ethiopia, Eritrea, Sri Lanka, and Saudi Arabia as perpetrators of transnational repression, but stresses that this list is actually not exhaustive. For those of you who might not be familiar with this threat, or who may have some difficulties grasping the consequences it may have on the victims, I'd like to share some numbers with you. Those are not in the report, but I thought it would be interesting to bring those to provide some context to our participants here today. They reflect the growth of the phenomenon of transnational repression for the past 15 years and how frequent the use of violence has become. So let's look at them. Over the last decade, there have been at least 14 suspected Russian assassinations on British soil, carried out by state actors or criminal networks under their direction, according to media reporting. Iran has carried out 34 violent operations targeting dissidents since 2021 and has plotted lethal actions against Canadians here. In the UK alone, the MI5 claimed that Iran was responsible for at least 20 assassination or kidnapping attempts since January 2022. Based on the numbers provided by the NGO Safeguard Defenders, in at least 27 occasions, the Chinese police managed to persuade targets from Canada to return back to the PRC. At least 83 successful forced returns were carried out globally by the PRC, counting only those achieved with the help of overseas police service stations. According to the media, more than 118 kidnappings have been orchestrated by the Turkish Foreign Intelligence Service, the MIT, over the past decade. The same service was seeking information on 15 targets located in Canada 5 years ago. Since 2010, at least half a dozen Rwandan dissidents were attacked or died under suspicious circumstances in neighboring African countries, but also in Europe, with a suspected killing as recently as 2022 in Belgium. In 2014, a Canadian author who wrote about Rwanda was placed under Belgian protection when she traveled there for fear of harm emanating from the Rwandan embassy in Brussels. India is reportedly linked to at least 20 murders in Pakistan since 2020, based on media reporting, and of 2 murders here in Canada using criminal gangs. This led to the expulsion of 6 diplomats from Canada who were believed by the Canadian government to be involved in collecting information to support these operations. And the list goes on and on. This is just a very short snapshot of what Canadian communities and dissidents around the world are facing on a daily basis, fearing that they or their family will be harmed or killed. With the upcoming federal election, this might be a threat that will fall under the radar, but it's a very important and serious threat that continues regardless of the political party in power. Fully recognizing this threat for what it is a crucial step in having the courage to take the necessary measures and make the changes needed to counter it. I also agree with Justice Hogue in her report that the federal government finally seems to realize the extent of the threat posed by foreign interference and has taken some steps to combat it. For example, Bill C-70 is a very good bill that brings the legislation up to date, and Jerry will give you a very good overview after my presentation. However, I also agree with the Commission that these measures alone are not sufficient. In particular, the RCMP lacks the resources to combat this threat, and the Canadian government as a whole lacks a national strategy. 2 gaps Justice Hogue recommends addressing in her recommendation 8 and 37. Yet, I think Justice Hogue doesn't go far enough on this point. I found that she seems generally satisfied with the current efforts undertaken by the federal government. I believe she did not seize the opportunity to question the current structures and ways of doing things, describing them as well thought out, sound, and efficient. In my opinion, the scale of this threat requires us to think differently. It means becoming more agile in our fight than what is needed in counterterrorism, but also much more transparent than counter-espionage operations require us to be. The whole of government approach to specifically combat transnational repression should be based on what I call the 4 Ps continuum: protect, prevent, punish, and publicize. It should aim to have an effect in the real world, on the threat actors, but also on the victims. As Justice Hogue points out, the machinery of government must facilitate action, not paralyze it. For instance, let's try to rethink what has been and still is a very successful model for counterterrorism: the INSETs, the Integrated National Security Enforcement Teams, led by the RCMP. I believe we could create transnational repression task forces instead. Indeed, it might be a good idea to use a different model for combating foreign interference. This would be a structure where all agencies with a mandate to collect or have an effect on the 4 Ps are brought together with the delegated power to take measures within their respective mandate using a problem-driven approach. The RCMP acknowledged that prosecution are no longer necessarily the gold standard of threat mitigation. It now favors disruption. So let's bring together all the other agencies that can disrupt or impact the threat actors, their operations, and networks, and protect the victims. Collaboration is already ongoing between the different federal departments on this issue, and don't get me wrong, they are doing a great job. But each one continues to work separately with their own agenda and priorities. A designated task force will alleviate that and make it for a real concerted effort. So this is it for me. I thought I will keep it short and give you the opportunity to ask more questions after my presentation and Jerry's presentation. I hope I brought some new point of view regarding foreign interference in Canada. and I will gladly take your question after Jerry. I now turn the floor to him for his expert opinion on Bill C-70 and the report from the public inquiry. To you, Jerry.
Thank you, Guillaume. My name is Jerry Norbert. Welcome the opportunity to talk to you about Bill C-70 and the recommendations of the Hogue report. Just as a matter of background, quickly, I've been in the national security realm since 1993. I've worked mainly at Justice, but spent some time at PCU as well. And I will be offering a course in the next few months to dealing more specifically with the status of the legislation in Canada with respect to foreign interference. Bill C-70 was tabled and adopted during the course of the inquiry. Actually, it was adopted, but still not in force, some aspect of it, last June. It was a bit surprising to have the government move ahead, I think, before the commissioner actually had the opportunity to provide her recommendations. At the same time, it probably was an answer to a political requirement, political need to move ahead. Chapter 16, which is what was before Bill C-70, is an act respecting foreign interference. Some aspects of this legislation are more direct, if you want, in addressing foreign interference, while others have a more indirect impact. The act was divided in 4 parts. The first one with respect to the CSIS Act, and I'll talk about one or two aspects of the amendments that were brought. The second one deals with countering foreign interference, and I will focus on the changes to the Security of Information Act, which is now the Foreign Interference and Security of Information Act. The third part deals with protecting information. And there were was a major amendment to the Canada Evidence Act that we'll touch upon very briefly to explain what that change is. And finally, the Foreign Influence, Transparency and Accountability Act, or I'll refer to as FITA, which is basically the foreign registry that had been in discussion for some time, and that our allies have, except for the UK, who recently passed it, but Australia and the United States had legislation already. So let me start with the amendments or the changes brought by Bill C-70. The CSIS Act, first of all, to me, the main change has to do with the ability to disclose information. The Section 19 2A has been modified. It used to be providing for disclosure for peace officers with respect to alleged contravention. Now it's been expanded to any person having jurisdiction to investigate. This just brings it outside of the realm of the police officers only. So this would actually enable the commissioner of FITA to receive information from CSIS because of his or her jurisdiction to investigate contravention under the FITA legislation. 19.2d deals with the ability in situations where, in the opinion of the minister, disclosure of information should be provided. It used to refer to any minister. Now it deals with to any person or entity. So again, an expansion of the ability to share, to disclose information, not share, but disclose information. And 19.2.1, which is totally new, basically allowing the service for the purpose of building resiliency against threats to, again, disclose to any person or entity if certain conditions are met. The first one being that the information must have already been provided to a federal department or agency. In other words, been dealt with internally first, and that it does not contain any personal information. This is something that had been in discussion for some time as well, and it will definitely bring an impact, a positive impact, with respect to the ability to inform the public. And once the public is better informed, then the public is more aware and alert to this. The second aspect that I wanted to discuss about Bill C-70 are the changes made to the Security of Information Act. There are a number of new offenses, criminal offenses, dealing with foreign interference. The first one I'd like to raise is subsection 21, which basically covers whether when a person is at the direction of, for the benefit of, or in association with a foreign entity, if a person induces or attempts to induce by intimidation, threat, or violence any person to do anything or cause anything to be done, it will be now an offense. This is to some extent a mirror of an existing offense that focuses on any activity. So it could be pressuring someone to vote in a certain way. The huge difference really is about subsection 2, that basically provides for if an activity takes place outside Canada, well, it will be deemed to have been committed in Canada if a number of conditions are met. Excuse me. If the victim is in Canada, or if the victim is outside Canada and the person or the victim or both are a citizen, a person who ordinarily resides in Canada, or even a person who's locally engaged outside in a mission. Excuse me. This will bring the jurisdiction of the activity in Canada. Or if the person, the intimidation, violence, or threat is in relation to the victim's child, relative, or intimate partner, it will also be captured. Excuse me. This basically covers the situation of transnational regression, as Guillaume was saying. Excuse me. This will provide for situations where activities taking place abroad will be able to be investigated and prosecuted in Canada. The next one that I wanted to discuss, there are 4 actually new offenses, is 20.4. That focuses on situation where a political process or governmental process is being influenced. This will now be captured. Political process is defined. Excuse me, among other things, to cover where the nomination of a candidate or the development of an electoral platform by a political party. We've heard throughout the commission of situations where this has occurred. So now the RSMB would have the ability to investigate and prosecute in such a situation. My voice is killing me, sorry. With respect to the Canada Evidence Act changes, I'll just say that 38.2 creates a regime for administrative review proceedings. In a nutshell, what this will allow is the ability, if there is a judicial review of a decision made by the commissioner under FITA, the federal court would hear this, will have the ability to consider information, sensitive information, that was considered by the commissioner in making his or her decision, while not disclosing this information to the affected person. Of course, there is a provision for a fair trial or a fair process. So if the judge ultimately decides that it would not be fair for the person not to get a full summary, then some decision might be made as remedy. But 38.33 sub 4 makes it very clear that the judge could base its decision on information, even if a summary of that information has not been provided to the non-government party. This basically will allow, in the context of a decision made by the commissioner, in the course of an administrative process, to use sensitive information. My voice was good before. Sorry about that. The foreign registry basically is to me, the most important part of this bill. Basically puts an obligation on anyone within 14 days of creating an arrangement with a foreign entity to provide information to the commissioner. The information to be provided would be described in the regulations. So essentially, if a person is in a situation where undertakes to carry out under the direction of the association with a foreign principal, the activities that would be contemplated would be to communicate with the public office holder, communicate certain information, or distribute money. Then this type of arrangement would be captured, and any person would be required to provide information to the commissioner. Specifically, the person does not have to register. That's the responsibility of the commissioner to create a registry and put some information in it. But clearly, the information must be provided. This covers basically both legitimate and illegitimate activities, overt and covert ones. So it's going to be a huge mandate, if you want, for this new commission. Of course, it's not expected that those who are involved in illegal activities will register. Hence, the ability for the commissioner to investigate, because the commissioner, the FITA, will have some very clear powers to investigate under the Act. And also, once the investigation is finalized, if the commissioner believes that the person has contravened one of the three obligations, which is to either provide information, update the information, or if the information provided is wrong, is not is misleading, if you want, then the commissioner would have two options: to go through the administrative route or the criminal route. Administratively, a notice of violation would be sent by the commissioner, and within 30 days, the individual has the option of either paying the fine or making representations. If the person pays it, that's the end of the file. If the person ignores and that does nothing, then he's deemed to have committed the violation after 30 days. If representations are made, the commissioner would then decide on a balance of probability whether the person has contravened, in fact, like by having failed to provide information or update the information, has failed to do that obligation. And that, if the after representations are made, the commissioner still believes that the act has been committed, and then that person could then go and do a judicial review to the federal court. And I bring you back to the Canada Evidence Act new regime. And this essentially means that a federal court judge could decide to consider information that would be otherwise be sensitive, not release it, with the goal being, of course, that a summary would be provided to the person, basically the regime that we have for security certificates in other areas. So if ultimately the minister confirms the violation, then in the registry, the Act says that the commissioner must make public the nature of the violation, the name of the person who committed the violation, the penalty imposed. Those are obligations. But the commissioner may also include the reasons for the decision, any relevant facts, analysis, and consideration that help reach the decision. So to me, that will really be the deterrent. aspect of it is that even though one should choose to go through the administrative route, where only a fine is imposed, the fact that the individual's name, the violator, would be in a public registry will probably bring people to think twice about before going ahead and engaging into arrangements with foreign entities. Certainly that is the goal the government wants to attain. With respect to the recommendations made by the Commissioner Hogue, 51 recommendations have been made. Of course, many of them are aimed at the election period around that time, and others are in-house measures. I do not intend to go over all of them, but I would like to raise a few that are of importance to me. The first one is the fact that the Commissioner Hogue is recommending that the priority should be given to develop a whole of government foreign interference strategy, and in the context of a renewed national security strategy. To me, that's a must. This will answer a number of the concerns that Guillaume has raised as far as to bring some uniformity in a number of areas, the definitions and the approach. So with a good, strong strategy, it is the umbrella that would allow the government to then, from there, go lower into and avoid having silos, as Guillaume was saying. Another aspect also is all the aspects about the ability for having having an accessible point of contact or a hotline to report foreign interference activities. This is really kind of a day-to-day operation, but it clearly is something that would be extremely useful as far as I'm concerned. There's also the duty to warn with respect to any credible threats made to Canadian or to any person within Canada. This, of course, would also, to me, encompass situations that the criminal offense captures as far as things having occurred outside Canada. So basically, transnational repression would be captured by this. The duty to inform specific parliamentarian when some are targeted. So all of this would, to me, bring an added value to the whole, if you want, our way of combating foreign interference. Lastly, recommendation 25 is one of importance to me as well, because it calls for members of parliament, senators, and their staff to be encouraged to check whether those with whom they interact are listed on FITA. This would be another way of ensuring that everyone that should be listed is listed. There are some recommendations with respect to the RCMP to be adequately resourced. That I think is vital in this area in order for them to investigate and disrupt, and also prioritize the recruitment and training in transnational repression is something of importance to me. So there is, like I said, a number of areas that the commissioner presented a very good report with some very solid recommendations. There was not too much discussion in the report about Bill 70. I believe that the commissioner probably felt that this should be left with the government, and she did not propose any changes or amendments to any of those legislative reforms, which is fine. But I think that her recommendations really go to the day-to-day operations of, and oftentimes these these are areas where, if you want some good results, where you need to focus on. So I really commend this report and their recommendations. So essentially, this is, I'm sorry for my voice that that left me for a minute. So these are the comments that I wanted to make.
Well, thank you very much, Jerry and Guillaume. Very, very insightful. Looking at the Q&A, it's not filling up. So I have a few questions for each of you. Guillaume, on the TNR side, I mean, those were pretty impressive statistics. Very depressing, but impressive. The numbers in the last, I think, 4 or 5 years of various states, and I know that's only a sample. A couple other states we could put in there. I guess my question is twofold. One, do you think it's getting worse in Canada in terms of Canada being a playground, if you wish, for foreign states in these activities leading up to assassinations? And related to that, one of the things we often hear, I've heard this in forum, particularly the one we had last year, or even community outreach, a lot in the diaspora groups are saying, we have things happening to us, but we don't know who to call. We don't know who to reach out to. And I was wondering, what insights you have on that in terms of various communities. So is it getting worse? And what do people do when they are subject to a repressive regime's harassment?
Yeah, thank you, Dan. Two very good questions. Let me just take the second one here. In terms of your first question, it's very hard to say if Canada is increasing compared to others. I think it's increasing from a global perspective. There's more refugees around the world, geopolitical conflicts, the natural disasters. Many conditions create more refugees. And if you look at the number of refugees in Canada, you see a clear increase in the past years. So obviously, more refugee here, more conflicts overseas, more autocratic countries as well. That makes for an increase globally. So I wouldn't say Canada is more at risk than other countries. I think all democracies that welcome with open arms dissidents and political refugees will see an increase. But that's for sure, Canada will not be spared from that. In terms of where to report, I think that's an issue that the commissioner highlighted in a report. She mentions that CSIS now has a tip line for foreign friends. And to be honest, I was surprised. I tried to find it, couldn't find it.
No.
Maybe it exists, but if I cannot find it, how would a Rwandan dissident find it, right?
Yeah.
So I think having a place where, and that goes back to my idea of having a specific task force where those type of reporting could be triage and assigned to teams that have the necessary resources and mandate to respond. So yeah, right now the best way is to kind of do it with your local police, perhaps the RCMP, because we know the RCMP would pass it on to CSIS. Perhaps do it with the RCMP and CSIS. But even myself, who has worked within the intelligence community, I don't have a clear answer where's the best place to report for a victim. So I cannot even imagine a victim that doesn't speak either French or English trying to find a place to report. And I think it's a major issue that Justice Hogue is trying to address in her recommendations.
Yeah, thank you. And particularly, again, most of the people come from communities where they're reticent about talking to officials, whether it's police or intelligence. Question from Matthew Fleury. Curious, so this would be for either of you. Curious about the political nominations, party influence, or other agents in media, foreign service, business, criminal gangs, etc.
Well, I'm going to start with both the new criminal offenses as well as the foreign registry legislation refer and define a political or governmental process. Actually, the definition is very similar. So in order to be captured under, again, either this new criminal offense or under the obligation, if you are a person that engages or undertakes activities under an arrangement with a foreign entity, if this definition is met, if one of the activities is is met, then there is the obligation, because it's not just for any activity that the obligation to register or to provide information exists. It has to be with respect to a political or governmental process. So it's hard to say with respect to the language that has been provided, if that would be captured. One would need to look at the definition. But like I did mention, this definition includes the nomination of a candidate or the development of an electoral platform by a political party. So if you are in a situation where what is expected of you is to provide or engage in such activities with respect to the foreign entity, then you would need to provide this information to the commissioner. Of course, most will say, well, what if this is illegal? Why would they have to report? Of course, oftentimes it's not expected that these folks will sign up and send the information to the commissioner. It will be up to the commissioner to, at times, try to find those people who are engaging in activities such as this, and basically come to the conclusion that there has been a contravention because the person has failed to provide this information, and then the person would become known publicly in the context of the registry. So that would be the end goal. So as is the case for many things, one needs to look at the devil is in the detail. You need to look at what the information is, what the activity is, and determine if that's captured or not by either legislation.
Okay, thank you.
Can I just
Yeah, absolutely. Yeah.
talk about the criminal gangs, or not only the term that was used aspect of it. In terms of transnational repression, when we look at the proxies and the actors involved, we see two very distinct trends in the past couple of years. The first one is the use of private investigators are trying to recruit police officers or any law enforcement personnel that have access to sensitive databases. The objective is to try to use that information, use the private investigators to locate the targets overseas, even try to leverage the presence, the physical presence of the private investigators to threaten them. Often those private investigators don't really know who they're working for, and I think there's an increasing acknowledgement or understanding of this threat. And I think CSIS and the RCP did great work, I think a year or two ago, I can't recall specifically when, trying to sensitize the private investigator community of this threat. But we've seen it with the RCP charging two former Mounties for working for the PRC, one active RCMP officer for working and passing CPIC information to Rwanda. So that's a trend in Canada, but also overseas. The second one, to answer the question, is the use of criminal elements, criminal gangs. And we've seen that in Canada with the Indian case. Just look at who has been charged for the murder of Ardem Sikh Nijar. They are members of an Indian criminal gang here. Iran, so the MOIS, the internal Iranian security service, has used a network to try to assassinate people in North America. And they've actually used criminal contacts to hire a Hells Angels member in Canada and British Columbia that ask an affiliate to arrange for the killing of targets in the US. And those are just some examples of, yes, of course, criminal gangs are being used increasingly, and it gives the countries of origin, so the perpetrators, some distance and some deniability if ever they are discovered or caught in the operation.
Yeah. Well, thank you for that. And just on that, those I worked a lot in counterintelligence, and historically, security intelligence services, even the hostile ones, stayed away from criminal elements. They just didn't, because they were unreliable and they weren't secure operations. But that's what we're seeing more in these killings, is that they're actually engaging them. So next question, Rob Mendoza, great to have you here, Rob. Thank you both for a fantastic set of presentations. Any additional aspects, functions, or authorities of Bill C-70 that you would have liked to see in the final bill? Additionally, do you think that our review organizations, NZERA and NISACOB, require any amendments to their enabling legislation to better help address any FI issues? Thank you. That's interesting.
I don't think that from an NCRA and NCICA perspective that there is any change. I think their mandate is quite wide to capture any new changes to legislation, for instance. It's a matter of where they want to focus their attention. I mean, if anything, it should be maybe it's up to them to decide. Obviously, they hear what's going on, so one would have to presume that they will focus their reviews, hopefully, in the next year or so on these new provisions and provide, because they had provided some insights already on foreign interference in the last year or so. So now that the bill is out, it will be interesting to see, and it's being applied. But again, the short answer is that I think that the review agencies are fine. With respect to any additional changes there are some, I think there are some tweaking maybe with respect to the foreign registry. I've looked and studied the Australian regime, the UK and the US regimes, which are very similar to ours. But we have I think the distinct advantage of having this administrative venue that they don't have. And I'm happy to say that this was suggested by Dan and I when we, as PDI officials, were asked about a year and a half ago to comment on the government proposal, which became the foreign registry. And at the time, none of that was part of their proposal. So it's something that we, PDI here, offered, suggested, happy to see that it was incorporated. But there are some technical aspects that also could be of use that other legislation provide for. There is under I believe it's the Australian regime legislation, the ability for the government to identify some proxies specifically, so that those who work for a proxy, for instance, would know that they're working for a foreign entity. So this would bring some more clarity to someone who might claim, well, I didn't know that this guy was working for the Indian government, for instance. So if you name them, those proxies, the known proxies in a schedule, then it just ties into the obligation for anyone who's embarking in an agreement with the proxy that they would be put on notice that this is really a foreign entity you're working for. But
Okay.
besides that, I think that the criminal offenses are good. Offhand, there's nothing per se that I can think of that could be added.
Okay, great. Thanks, Jerry. We're getting a bounty of questions now, both Q&A and chat. This is great. So question for you, Jerry. Question for Gerard. What are the main differences to Section 38 of the CEA? Main differences?
Well, the addition of 38.2 is that 38 is about disclosure, period. There is a 38.206, there's a component that provides for the use as admissible evidence, but it's that totally different. 38 regime is about disclosure. The main addition now is that there is a reference to a federal proceeding, and federal proceeding is defined. And that's in and of itself is a component. So if you are in a federal proceeding, that basically says, well, it's a judicial review or an appeal from of a decision from a federal board, commission, or other tribunal as defined by the Federal Courts Act. Then if there is a JR or an appeal, then 38.2 would apply. This means that if there is a disclosure issue, or there's again, as far as the normal regime goes, if there's someone believes that he will cause the disclosure of sensitive information, a notice must be sent. So you have this regime within the regime that would apply to federal proceeding. The main distinction is that this will allow the one who is performing the review under the JR, the federal court, would be the same that would be dealing with the disclosure element. And that is 38.32 that states that the judge who hears the motion brought under 38.25, which is if there was a notice of disclosure, basically, becomes seized of all matters in the federal proceeding. So it would be one judge dealing with disclosure and decision making that we currently don't have. So that's the main distinction in the fact that the provisions clearly provide for this person to basically use the sensitive information in the context of the decision-making process for the JR, while providing a summary, or even it provide that even if the information cannot be summarized, still the judge could use that, the federal court judge could use that. So that's really something that was not in the Canada Evidence Act before. And that is now, I think, is going to be very useful, not only in the context of FITA, but except for the security certificate, a number of other regimes like the no-fly and all that have been, by this legislation, C-70 has been, what we had there has been taken out, so that this 38.2 process would apply now for instance, the no-fly list provisions that we had before with respect to dealing with sensitive information.
Okay, thanks, Jerry. And a question from John Pratt. Can any of the panelists speak to the importance of transparency in combating FI, including in government communications and processes, but also more generally with respect to financial transparency laws and regulations?
I can speak to the transnational aspect of it, and I mentioned it in my presentation. We have to be transparent as much as possible. I think that would apply to foreign interference more generally, but I'm not an expert on foreign interference against democratic institutions. The transnational repression, yes. We need to be transparent, but actively transparent, trying to reach as much communities as possible, communicate on the threat. If you look at the past 10 years at the CSIS annual reports, there's one paragraph on foreign interference and one generic line on transnational repression. If you look at their last annual report, so the 2023, there's a lot of information on Iran lethal operations, on the Chinese police overseas service station. So communicating the information on the threat will definitely help the communities to protect themselves, will help partners locally, local police to be aware of that threat, to adapt their posture, to know how to report, to deal with a victim that reports some abuse, some threats. So yes, transparency specifically on the threat actors. The US is even looking at a bill right now to force the government or to require the government to publicize a list of actors involved in transnational repression. So I think that could be a gold standard we should aim for. But definitely transnational repression requires transparency. And I think it's hard for the agencies that traditionally have been working counter intelligence operations, counter espionage operations, to be transparent with the public. But we're getting there, but we're not there yet.
I would add then that I think that the changes made to Section 19, the addition of this power to build resiliency will be of great use. I think that's been the service intent to disclose as much as possible as it could in the past few years, but it was prevented from doing so. Now this clear provision really sets the tone, I think, for the future. And it is to be expected that more transparency will come out of the service, which is, of course, a main player with respect to this aspect.
Okay, I have a question from Andrea. So again, it would be to, sorry, I missed one, to Elise. Do you think scientists are increasingly vulnerable to transnational oppression? Maybe. Yeah.
Yeah, it depends. I think there's two parts to that question. First of all, we're talking about foreign scientists, I assume foreign students, foreign researchers, foreign professors here in Canada, working here in Canada. I think it depends. They're humans, right? So they are doing things outside of their work. What are they doing? Are they actively protesting against a specific authoritarian country? Are they Falun Gong followers? So it really depends on what they're doing. And often employers do not really care about what their employees are doing outside of the work, but then they end up having an employee stuck in Algeria because he or they were a dissident and they didn't know. So now they have to deal with an employee that was jailed or is under an exit ban in a foreign country because of their extracurriculum activities. The other part is that universities are a place where there's a lot of transnational repression going on because it's an open space. You have students that are often funded by a specific country that are there. They're meeting dissidents at events, at courses. So it's a very unique place where you find victims and you also find actors. And student associations are used by foreign countries to deploy transnational repression. Often they are the presidents are elected or suggested by the embassy. They will organize meeting with diplomats for the students in that specific university. So there's a dynamic there. There's a network that is connected often with the embassy or the consulates. So obviously the universities are more at risk of transnational repression, but not any scientists are more could be more targeted. It depends on their profile and what they're doing outside of their work.
Yeah, and I just want to add on that at the risk of sounding sensitive, I also think the government in some way is going over the top in terms of denying visas for some students, for some researchers, based on nothing short of profiling. And there've been some in the media, I'm sure a lot of you have seen, where someone's going to study physics, let's say at Waterloo, and they've been denied it at risk of committing espionage and things like this. They're using national security in kind of the wrong way, in my opinion, and sort of maybe missing the ones that might be worthy of a denial. But anyway, it's a direction I don't think we should be going in. So, Andrea, what are your thoughts about foreign interference countermeasures with the increase of social media misinformation and disinformation?
Can you repeat that?
Thoughts about foreign interference countermeasures with the increase of social media misinformation and disinformation?
Well, it's clearly an important aspect of misinformation, disinformation aspect. It's one that I think one of the most important aspects that the government in the US is focusing on. The report does refer to that. The report refers more particularly to section, I think it's recommendation 48, that provides for I'm just going to go there. Yeah, the government should explore existing technologies and consider assisting civil society organization to develop a publicly available tool to help citizens verify whether digital content is fabricated or altered. It is obviously an ongoing part. It will be a part of the task. I think that the both law enforcement and intelligence services will need to take into consideration in the way that they approach their the provisions applying to them specifically. There's no doubt that it's going to be it will add to the already difficult task of investigating these type of activities, and bringing, for instance, if we talk about the RCMP, bringing some evidence, admissible evidence, before a court of law to prosecute a person. One will have to ensure that it's what is being used is not fabricated evidence. So I think it will be this is something that the government in their overall approach, and as per the recommendation of the Justice Hogue to develop this whole of government foreign interference strategy, will undoubtedly need to cover and explore ways of dealing with this new phenomena.
Okay. I'm just going to go to the next question. Jennifer Irish. Hi, Jennifer. UNESCO has just started a program to protect scientists with similar measures used to protect journalists, given that they are being increasingly targeted just for ensuring info integrity in their communications. Info Integrity Lab, it's at Ottawa U, is featuring challenges faced by science communications at our Disinfo and Climate Change Summit in June.
I think it was not a question, but
yeah, that's a comment.
I'll just support
That was more a comment.
Digital Lab and Citizens Lab at the University of Toronto are doing a very amazing, fantastic work on transnational repression, specifically digital transnational repression. And I've seen in the comments as well, there was an Amnesty International report that was shared. I highly recommend that report. It talks about transnational repression against students and scholars. A lot of interviews that were being done by Amnesty with victims. I highly recommend it if you work in the academic or university sector. Go check it out.
Okay. Just I'm going to jump back here to get in order here. I think this is more for you, Jerry. I was actually thinking of this when you were talking about people overseas. In these changes, how would someone living abroad influencing on Canadian soil be accountable? I guess this is going back to subsection 2 of SOIA when you were talking about outside of Canada.
Well, again, the details, the devil's in the detail. I mean, there are some offenses for which, like I mentioned, 20 sub 2 that discusses situations where an activity committed outside would be deemed to have been committed in Canada. So if the victim is in Canada, then it's captured, even if the person is abroad. Or if the victim is outside Canada, let's say both are occurring outside, someone from Canada going abroad and putting some pressure on the community abroad from the diaspora here, then if the person or the victim are Canadian, one of them is Canadian citizen or person who ordinarily resides in Canada, it would be captured. And of course, if the person's abroad, how do we do that? Well, there are some arrangement that the RCB has with some countries where they can enter into an arrangement. At times, the RCB will go abroad and be allowed to investigate, perform their investigation. Or to MLAT, if the person is flying here, is being arrested when he lands, then there's an MLAT, mutual legal assistance treaty process that can kick in, and for which the evidence captured or collected abroad could be used here in the context of a prosecution. So there's a number of facets of possibilities. Clearly, with the new offense in the Foreign Interference and Security of Information Act, it will provide much more flexibility for the RCB to investigate. And again, it's not because something occurs abroad that we cannot have the RCB investigated if Canada has jurisdiction to investigate and to prosecute in Canada.
Okay, great. Thanks, Jerry. So this is interesting. Latest news about one of the Liberal candidates has been questioned about foreign interference. Should this be Canadian enforcement to identify and investigate who are those people that under the investigation for the foreign interference? If these people under investigation, surely should they not be the leaders of any parties or organizations for Canadian government? So that must be what I saw today in the media about a Liberal candidate. So should the Canadian enforcement include identify and investigate, I guess, and who are those people under investigation? Anybody, either of you want to take a stab?
My first stab at this would be the commissioner made the reference to a number of amendments that the chief electoral officer was making. I cannot recall them by heart, but anything having to do with the internal politics is certainly something that will be looked at by the government. we're just at the days following the report, the release of the report. We can expect the government to come up with some position with respect to these recommendations specifically. And although I don't have the answer to the specific question being raised, clearly this is something that the type of issue, the type of question of interrogation that the government will be focusing on, as I'm sure that this situation would be covered by one of the recommendations of the chief electoral officer, because there were a number of them that were mentioned in the report.
Okay, one from Margaret Ann Kellett. Let's see this here. You indicated that targets to access information through law enforcement was identified. In your experience, have you noted if government institutions are also being targeted to access information? And if so, what do you think is required to strengthen our defenses?
I think might be a reference to what I was saying earlier about the two trends. Actually, for a foreign state, anyone who has access to information that might help them locate targets could be themselves a target for recruitment. Think about immigration officer. Think about doctors. We've seen cases. I think it was ASIO, the Australian Security Intelligence Organization, 2 years ago in their annual report that mentioned doctors that were approached and the target of recruitment to get information, personal records of dissidents. So think about anyone who has access to databases or privileged information that could help, and could be Bell Canada. They have clients, so no one is spared from this threat. And can we strengthen our defenses? We can always do better. But I think it depends on department. It depends on if it's detected, if those databases are appropriately secured. With the case of the RCMP officer that was passing CPIC information to Rwanda, I think from what I could read about the case, the RCMP was very quick to detect and take action. So it depends on the security of those systems and the internal security of each department or organization that those employees work for.
Okay, and well, talking about secure databases, that's a nice segue to our next question. And Elon Musk. Question is there any action from the Canadian government on Elon Musk's post which somehow could influence the future of Canada's general election, party election? I mean, that's interesting because we've seen him interfering in the UK and Germany and everywhere else. You guys want to take a stab at that?
I would just say that the Section 2B of the CSIS Act defines foreign interference as clandestine or deceptive. So if Elon Musk is doing it openly, it's not clandestine or deceptive. It could be harmful for our democracy, but I don't think it fits under what we consider foreign interference in Canada.
I agree. I think it's people can make comment all they want. I mean, it's very open, and even with respect to the registry, I don't think we are in a situation where a person is basically undertaking activity in the context of a political or government process in Canada per se. That for a foreign entity trying to gain an advantage. I mean. And even that, if that was the case, then that person would have to provide the prescribed information to the commissioner, and the ultimate goal would be to identify this person publicly. Well, he's doing that himself. I mean, it's not, with respect to the registry, it's not something that would be attracted by this, and I don't think we're in a situation where also a criminal offense would apply.
Yeah, I agree with you. I think when all our national security legislation was drafted, we never imagined an Elon Musk with his own platform.
No.
Okay, so in the next question, we get this here. How will these changes and recommendations impact the government of Canada's security screening operations. Information sharing between government entities is currently very limited.
Well, the information sharing, I think that is, I don't think it's limited. Honestly, there is the Security of Canada Intelligence Disclosure Act, or Information Disclosure SKIDA, that has been in existence for years. It's being used. It's a great tool to share, disclose information among agencies that are involved in national security work, in addition to other existing mechanisms to share information. Uh, Obviously, from a security assessment, this is something that the service has always taken into account, because the service has a mandate to investigate for the purpose of security clearances, security assessments under its act. And the 2B has always been there. Now it's expanded. There's more light on this. So it's certainly something that will be increasingly considered by the service in any security assessment, either people entering the country, or for the issue of clearances, or for citizenship issues. So the more light on an aspect of an already existing mandate, which, as Guillaume said, it has been in the CSIS mandate since 1984. This is not new. We're talking more about this now, but it's been always there. So it just brings more light to this, and so it clearly then would be taken into consideration by the service even more.
Okay, this question, this is an interesting one. I like this. Jennifer, is the government required or encouraged to respond to the inquiry recommendations? Whoops, I just lost this. Including if there is a change in government, what measures should be taken to ensure more public awareness of the recommendations and observations, including on disinformation? Public awareness seems to be declining in inquiry at a time when there should be more vigilant in the lead up to elections.
Well, my experience with respect to commission of inquiry, I was involved in 3 from a government side in the early 2000s. And the government is, these recommendations are made to the government, because it is the government who creates commission of inquiry. This one was with all parties agreeing to move ahead and to appoint Commissioner Hogue. So it is expected that there will be an answer, by the government. Now, when that will take place, I would venture that the Liberal government would be wrong not to deal with that before an election. They should move ahead and take a stance with respect to these. Maybe they are right now assessing whether all recommendations should be agreed to or not. But we can certainly expect that a position will be taken by a government, either the existing one or any one following an election.
I would just add to that my own view. If maybe the canary in the coal mine is going to be whether the new government, whether it's a minority or a majority, takes national security seriously. And I think the things we have to look for is NISACOP. There needs to be a new executive director. It needs to be staff. And then there's the National Security Council or Committee that I think sat 2 or 3 times in the last year and a half with the current government. If those institutions or entities aren't staffed or aren't energized in a way, to me, that would kind of telegraph that the government isn't taking national security seriously. And I think with that, I have my doubts the recommendations would be followed up. Okay. The threshold for SKIDA is pretty high. Are there other avenues to disclose to CSIS, such as the TBS policy on security event management, that can be leveraged to share information related to potential foreign interference?
I'm not sure exactly what is meant by very high. The only requirement by the act is if you are a federal organization and you want to disclose information to a designated agency, which you have 17 in the schedule. The only question you need to satisfy yourself is, does this fall within the mandate? That's it. And of course, you need to have it. It has to be in connection with an activity that would be security. There's a buzz term in the act that deals basically with the security aspect of the Canadian government. So and you would have the same type of threshold if you had with respect to any bilateral arrangements that currently exist, that existed before SCIDA, that has continued to exist after. So I think that SCIDA has enabled any and all federal institution, government institution, to push information to the service whenever this falls within the mandate of the service, and whether the information that is contemplated would meet the definition, which is extremely wide. Again, I forget the exact buzzword in SCIDA, but it deals with security situations of the government of Canada.
Okay, and this will be our last question. More of a helpful comment is from John Pratt. For TNR in the academic space, he recommends looking at this recent Amnesty International report. We've got the link, which describes the chilling effect of TNR on campuses, including researchers self-selecting out of academic careers. It's got the link right there. Well, thank you, John, for that. Okay, so that's it for questions and comments. And I want to thank everybody for those excellent questions. And I apologize if I missed one or if we didn't have enough time. We're just trying to manage the time here. This has been great. Jerry, thank you so much. And Guillaume, your expertise. We know this could have gone on longer with your backgrounds and research you've done on these subjects. It's very important. And I want to thank the participants for attending this webinar. It was impressive numbers, and thank you very much for support for this today.
Thank you to you. Thank you, Dan.
Thank you very much. Have a good day.
Bye.